Hello, everyone. Welcome to the Tools to Protect Your Brand webinar organized by LexisNexis IP together with the EUIPO. We're going to start with a poll to learn a little bit about the audience and what your experience with the EUIPO IP enforcement portal is. So please submit your answer when you see the poll window appear in your screen. My name is Ida Kambor, and I am the Head of Operations and Consultancy of the LexisNexis IP Online Brand Protection Department. Our international brand protection team is working with many brands to help them protect their IP online. We have an experienced team of consultants who use technology and help our clients to identify and remove IP infringements online. They also leverage technology to identify networks of bad actors, collect intelligence, and support clients as they connect online brand protection with offline efforts. And especially in offline efforts, cooperation with authorities and customs officials is extremely important for all brands. We wanted to arrange today's webinar to share information about an important tool to cooperate with authorities. EUIPO has developed a portal which helps brand owners to share information and work efficiently with officials in the EU and around the world. This is an impressive project, and we are very excited to learn more about it. Directly from the EUIPO expert, Nicole Semyevsky, who will be presenting the portal today. We will get an introduction into the EUIPO IP enforcement portal and discuss some of the recent brand protection trends. As we can see from the great number of participants and from the poll results, many of us would like to learn more about this portal, and this is why we are here today. Now we can see the poll results here. Thank you very much for answering. I'd like to proceed to introduce our speakers today. So representing EUIPO, we have Nicole, who is licensed in political sciences, in international relations and public administration. She works for the EUIPO since 2000. She started in the boards of appeal, then changed to the quality department, and today is the corporate, which is today the corporate governance department, and later switched to the international cooperation department. Since 2012, she's working for the observatory. She's part of the IP enforcement portal team, where she's responsible for the user management and trainings. So she's really the best person to tell us about the portal today. Thank you very much for joining, Nicole. We are thrilled to have you on the webinar today. We have also Francesca Tocco. She's the LexisNexis online brand protection consultant. She will be facilitating the discussion today between Nicole and the audience. Francesca has over 5 years experience in online brand protection. She's worked with many major brands across industries and has advised them on the best approach to protect their assets online and offline. Before I hand over to Francesca, I would like to tell a little bit about the practicalities for this session. As during the presentation, you will have the chance to submit questions. If I can have the next slide, thank you. Our speaker will then do her best to address all of the questions at the end of the presentation, so we'll have saved some time for that at the end. We have also included a couple of polls which will allow you to share your thoughts and experience about some of the topics we will be discussing today, just as we had in the beginning. And we also have a chat functionality available so that you can submit any additional thoughts there and share them with other professionals who are attending the webinar today. We have also shared the presentation materials in the handout section on the screen on the right, and the webinar will be recorded so you can watch it afterwards as well. We are thrilled to have so many participants joining today, and we hope that you will find valuable information for your work during the webinar. Thank you very much for joining. I'm happy to hand over to Francesca for a brief introduction of the topic, which will be followed by Nicole's presentation about the IP enforcement portal, and then we'll have a Q&A session at the end. Thank you.
Right. Thank you, Ida. Thank you and welcome, everyone. And a special thanks to Nicole for taking the time today to share the overview of the EUIPO IP enforcement portal, to which we will refer to IPEP. So thank you, everyone. I will be your host, and I will be monitoring the chat closely. So please feel free to submit your questions for Nicole or the LexisNexis team. Our main objective today will be to provide an educational opportunity to learn more about this powerful and free tool from EUIPO, and share also some proactive measures which right holders can take against the counterfeit challenges by leveraging the extensive network and collaborative approach which is fostered by EUIPO. Very briefly as well, this tool is actually not a brand new tool. It was created several years ago, and I'm sure Nicole can tell us more. But in recent months, it has seen some significant changes. I actually had the chance to already hear Nicole presenting and sharing some of these changes during the 2021 INTA virtual meeting. And I was especially impressed about one of these major developments, which is making the IP enforcement portal as a one-stop for e-filing and management point for all customs application for actions in EU. So this portal, again, it's very powerful. We will see the main features, and I can see as well from the initial polls that 47% of our audience today is not at all familiar, so I'm sure Nicole will be able to provide an extensive overview of the platform. So finally, before handing over to Nicole, working closely with a variety of brands on their brand protection projects, from my side, I can really say that partnership and collaboration is really one of the fundamental building blocks in the fight against counterfeit to protect the integrity and reputation of a brand. Therefore, for me, this webinar, it's an occasion to share great success examples of this type of collaboration between right holders, customs, or other enforcement authorities. And with that, I will leave the floor to you, Nicole. Thank you again.
Thank you so much for giving me the floor, and thank you, LexisNexis, for organizing this webinar, this event. As I was presented already, I don't have to say much about myself. Just a few words on the EUIPO, so the EU IP office. We recorded EU trademarks and community designs for the 27 member states. So it's a EU right that covers then the 27 member states automatically. And if you go to the next slide, we were entrusted back in 2012 with the Observatory on Infringements of IP Rights. So from passing only to registering trademarks and designs, we suddenly had also to look out at what happened after a right is protected. And this is not only concerning designs and trademarks, but any type of IP rights, so patents, geographical indications, whatever is out there. Copyrights. And one of the mandates we've got when the observatory was entrusted to our office was to build a tool that would help to put in contact right holders with enforcement authorities and to allow this exchange of information in a secure manner. So next slide. So the IP enforcement portal is a legal tool. We followed a mandate that was created to help for this secure exchange of information between enforcement authorities and right holders. If you go to the next slide. Basically, the idea is that right holders can open an account in the IP enforcement portal, upload their product, IPR, and contact information, and enforcers, they have a search bar and they can search for a brand, a company, or a type of product and get a hit on information that will help them to distinguish fake from genuine goods. So anything about when we speak about product information, images of originals versus fakes, authentication signs, labels, And then, of course, all this is linked to the IPR information that the right holder has uploaded. And when it comes to trademarks and designs, this information comes directly from our trademarks and design registers, which contain not only EU trademark information, but also the trademark of the national offices of the member states or the information of third countries, and the same for designs. So even if a right holder has no account in EUIPO, when enforcers do a search, they can at least see if there's a valid right that they can enforce. Of course, this tool is all about exchanging information. That's why it allows right holders to send customs applications for actions. We'll speak about them in a minute, or alerts, and enforcement authorities can send some notification. All this in a secure way. Next slide, please. For enforcers, the added value is that they do one search and get multiple search results from the various places. So they don't only get the search result from the information uploaded by the rights holders in EUIPO, but also, as I said, from our trademark registers, design registers, and all the other rights that are out there. When it comes to trademarks and designs, already we put some extra info there. We make sure that the rights they can view in the search result are only rights in status registered, so they know they can be enforced. And what we also do is we not only show the search results of EU trademarks that are valid in the EU, because the IP enforcement portal is about EU enforcement, but also the rights that can be found in our trademark register, TM view or design view, meaning also rights that right holders might have registered in third countries. Why is that? Because when it comes to goods in transit, for the customs official, it's very interesting to know whether the right holder has protected the right also in the country of destination, because then in the EU, customs can stop a good in transit. So they can find all this information in there. Next slide. Of course, for enforcers, the most important information is the contact points. It's not only about customs, it's also about internal market forces. It's not only police, but it's also market surveillance authorities and prosecutors that have access to the information in EUIPO. And for internal market investigation, the most important thing when it comes to looking at criminal organizations, and it's not so much the product information like customs, it's more on getting to know who to speak to and getting the contact point information. This is essential. So this is one of the key information for enforcement authorities. And if they search in EUIPO, they can find this information, and they can see who is the contact person in the member states, who speaks their language. Is it a technical person? It's a legal person. Of course, it might be one contact person that is responsible for the entire EU, but there might be also that there are specific contact persons in the different member states. So this information is crucial, and police always tells me 80% of the needs are covered if they know who to call to consult. So this is important. Next slide. Yes, when we speak, I want to stress again, when we speak about the IPR portfolio, the information that the right holder uploads regarding their IPR, when it comes to trademarks and designs, they're directly uploaded from our central registers. Same for geographical indications. And when it comes to other rights like copyrights, patents, plant variety, this information can be uploaded in EUIPO. In the case of patents, we are not linked with the EPO. It's very seldom that a good is actually stopped at the border based on a patent. The patent information is very heavy, and as we send this information backwards and forwards electronically, we have refrained from linking to the database and having too much information there. So basically what we leave in the case of patents, what the right holder does is he enters the information and he can upload his patent certificate and it gives this information and shares this information with the enforcers. But what enforcers really do, how they stop it, is basically because they recognize a brand or a design, or because they find a packaging that looks really suspicious. So that's a bit where we put the weight in. But we cover all IPR rights, and there's a lot of copyright also out there, so any right can be uploaded. Next slide, please. So when it comes to the product portfolio, of course, right holders, they can upload their product information. The idea is not to upload the entire product portfolio, but if you keep products that help enforcers to link it product to a brand and the brand to the rights holder. If there's a product that is particularly copied, then of course I will create an entry, but normally we invite right holders to group things, so they can enter a product line or a group of products if it's a smaller company, but that has it has different products, but where production places are the same, shipment is the same, packaging is the same. Makes sense to group things, because what we want is the enforcers, when they do a search and they do this keyword search, they get a hit very easily. So it is about entering a few products, entering information there. And what is very important, we have right now 72 enforcement authorities accessing the tool, but the rights holder decides with whom of those authorities they share the information. The rights holder has always control of who can view the information. The information is closed per default, and it's the rights holder who explicitly shares and opens the information to the various enforcement authorities that have access. Next slide. So the information, as you can imagine, is the typical information about images of originals versus fakes, information about the logistics. Again, here, the information also needs to be updated, so we rather have some key information entered there than trying to put too much information there that's outdated after a couple of months. This is a very fast-moving environment, so things change very quickly. But of course, customs look for clean-cut cases. I mean, if you have things like we only import in Rotterdam Harbor, or we only ship end products, or we ship only by land, air, sea, all this key information that will help enforcers to spot out the fakes, this is welcomed. You can enter your providers, you can enter the traders, information about packagings with images, all this information will help enforcers to spot fakes. Next slide. And I think the previous one, can you go one back? Yeah, exactly. So with all this information entered in EUIPO, it's very easy then to file an electronic customs applications for action. For those of you who are not familiar with the customs applications for action, is that in the EU, if you want customs to be active on your behalf at the border and stop fakes based on an IPR infringement, you need to file a customs application for action. It's like the mandate that you give customs to act on your behalf and look out for fakes, for copies. Here, there are two types of customs applications for actions. There's a union AFA that is applicable in various member states, or a national AFA, which is only applicable in one of the member states. The customs application for action has a validity of 1 year. It needs to be renewed. Why? Because, as I mentioned before, things change, and of course, customs would like to have updated data all the time. So the customs application for action can be filed through EUIPO, or this has happening since a number of years. And EUIPO also does a pre-admissibility check, meaning that when you file a customs application for action, the system takes you by the hand, points out when there's missing information, so we make sure all the mandatory information is included in the customs application for action, and you won't be able to send it off if there's any mandatory information missing. These customs applications for actions, they are regulated by Customs Regulation 608/2013, and the tool is completely adapted to the regulation. Next slide. As I've mentioned before, it's already since 2015 that you can file customs applications through EUIPO, but since our release last December, EUIPO has become the single e-filing and AFA management tool for 24 member states, and an alternative system for 3 member states, Germany, Spain, and Italy, who have their own national systems. What does it mean? It means that we're moving away from paper. Until now, the customs applications for actions could have been filed both electronically or in paper. We're moving away from paper to ensure the quality and the processing of the data contained in the customs applications for actions, in order that this data can be embedded in the risk profiling systems of customs. So this has been a big step. There's a lot of movement going on now in EUIPO for many of the right holders who were used to file the AFAs in paper. They're now moving to EUIPO to start to do the AFA renewals through EUIPO. lots of new things for right holders, but we have our team here to assist and help, and I will say a few words after my presentation to encourage you to reach out to our team if you need assistance. Next slide.
Nicole, sorry, if I may, before going to the next slide, it might be an obvious question, but since December 2021, of course, after Brexit, I believe that to file an application for action for UK, there is now a separate process, correct? I believe before December 21, the portal could also be used to file an application for UK or not? No, yeah, if you can tell us more, that would.
No, thank you for the question. No, since Brexit, UK was no longer part of the EU, so also no longer part of the EUIPO, and they left the whole copy system, the whole AFA system. UK was left, so they have a separate system, a national system for them. But as they sadly enough not longer in the EU, they're not longer part of the system. So okay. This is since Brexit. Mm-hmm.
Perfect. Okay.
This is also, if I may use, say a few words here too. One of the requisites that you need to file a customs applications for action in the EU is that you need an EURI number. The EURI number is like a tax identification number that is given by one of the member states and is then accepted by all the other authorities. For companies that are not in the EU, they can ask and request an EURI for in any of the member states and then use it for the AFA filing. All the companies who have exported or imported in the EU, they already have an EURI number. But if you plan to file a customs application fraction, it makes sense to make sure that the EURI name linked to the EURI number is also in the name of the right, it's the same name as the right holder, to not create confusion with customs. So if your company has an EURI number and this EURI number is different than the EURI name is different than the right holder name, it makes sense to request a new one. It doesn't cost anything. It takes like 24 hours to get it. You can request it in any of the member states and then get this EURI number. Because this EURI, the EURI name linked to EURI number is the name that will also appear in your customs applications for action. And for legal representatives, it's the same. They need to ask if they want to file an AFA on behalf of the right holder, they need also to request an EURI number. Same thing, it takes very little time. You can request it without major complication, but it will be your identification number towards EU Customs Administration. The added value of this is so once you have an account in EUIPO and you register your EURI number in EUIPO, you will automatically see if you've filed in the past AFAs in paper, wherever you file them, they will all appear in EUIPO and you will be able to see them and to manage them, to extend them or amend them or work with them. So this all is around the EURI number that you need to file. Again, in our landing page of the IP enforcement portal, you will find all the information detailed and links to also the customs information. So it's a lot of information. I don't want to drop too much, but the EURI number is an important chapter here. Okay, so I see we have moved to the next slide. Where customs have the customs application for action, they have had this information since years. The internal market forces in the EU, police, market surveillance authorities, they don't get this intelligence. So a way to pass this information along is the alerts functionality in EUIPO. Of course, when we develop the alerts, the aim or the first purpose of an alert, of course, is, as the name says, warn enforcement authorities of shipments coming in. So the idea would be if the right holder knows about a shipment coming in, that he has a secure and fast way of warning the enforcers or the concerned enforcement authority about the shipment. In practice, it's very seldom that the right holder actually has this information. But what we have found in the last years is that the alert is very similar to, when you look at the content of the alert, to what the customs application contents. So basically, it's contact information of the right holder, IPRs concerned, and if the information is shared, the linked products to the IPRs in EUIPO. So with one, it's a nice way of sending the alert to the enforcement authorities, especially the internal market enforcement authorities, to raise awareness and make them aware of the issues the right holder may have. We also have a second type of alert, which is the online infringement alert, which is alerts about web pages selling fakes. Now, this is something that big companies, of course, don't need. They have their own systems of monitoring websites. They have third-party providers who take care of that. But when it comes to small and medium-sized enterprise, they very often don't know where to start. And the online infringement alert is a very nice, also again, a nice way of getting the message out there, of pointing this out. Europol is always in copy of these online infringements, and also they take them into the listings when they do their closed down operations. The alerts have the same validity of, the same legal weight, I would say, as a telephone call or an email, so there's nothing binding, but it is a way of getting the information, of raising awareness and starting exchanges with the enforcement authorities in a secure way. The information never leaves the tool. It's email notifications that sent out with links, but the intelligence is always safely guarded and guarded in the tool. Okay, next slide, please.
Thank you, Nicole. And actually, I just wanted to stress on this specific feature, which I think for many brands trying to fight again and limit the presence of counterfeit can be an extremely useful feature. So just to be clear, the difference between submitting an AFA to customs and submitting an alert, either potential trend or infringement online, is that this type of alerts are sent not only to customs, but also to other enforcement authorities, such as police, for example. Is that correct? So AFAs are only shared with customs, whereas these alerts are also shared with other enforcement authorities.
Absolutely. So basically, in the customs application fraction, if you do union AFA, you choose in which member state you want the AFA to be applicable. It's not like the EU trademark that's automatically applicable in the 27 member states, but in the AFA, you choose in which member states you want the AFA to be applicable in. And there are legal consequences of filing an AFA. It's a legal mandate that you give. The alerts, as I said, you can choose who you want to alert. So you have you choose the receiver of your alert. So you can sort by member state or by authority, and you can decide who you want to send the alert to. And as I said, and this is an informal way of raising awareness, not legally binding. There's nothing behind, but it's a way of raising awareness and reaching out to the authorities that you want to reach out to. Yes, absolutely.
Okay, thank you.
And then we have the suspicious case, which again, it's the other way around. This is a way that enforcement authorities have in EUIPO to notify the right holder if they have found the suspicious goods that are suspicious of being IPR infringing. They can take some pictures, upload the pictures, and send them to the rights holders to get confirmation whether what they found is genuine or fake. These notifications, again, have the same characteristics as with the alert. The information never leaves the tool. All the pictures, everything is safely stored in the tool, and the only thing sent out are email notifications with links for the right holder to log in and to look and to check. Enforcers can set deadlines and then for the right holder to respond, and they get read receipts automatically. And the tool allows a multiple exchange of information. Now, customs and a number of police authorities have now started to, or have since a time now, started to use the suspicious case feature of EUIPO as a detention notification, as the official detention notification when they stop goods. So the tool has been adapted to the customs regulation, again here for customs, and the official notifications can take place through the tool. So Luxembourg Customs Authorities, Cyprus are the ones, or Budapest Airport Authority have started to notify the detentions, but also police like the Spanish police, Guardia Civil and the Cuerpo Nacional de Policía have started to use this as a notification system. So getting along there. Yeah, next slide.
Thank you. Sorry, before going to the next slide, you mentioned already how important it is that right holders share contact details, either legal or most often technical contact details, so that customs, or even in this case for alerts, for example, a police authority in the EU can contact the right holders to confirm and check that the goods are actually counterfeit. can you share briefly, it might not be the same for all countries, but usually how long, like 3 days or 10 days, how long the goods are retained, and if the right holders cannot be contacted or it does not answer within a certain deadline, what happens to those goods? What actions are taken?
We're speaking IP infringement here, so not to confuse with health and safety issues. So if goods are detained at the border and the right holder doesn't answer, does not pursue the goods are gone. The goods are released. And their time changes if it's different time frames if the goods are perishable or not. So that's obvious. The right holders are given a time. It depends a bit on the member states and on the authority, type of authority, what deadline is given. But normally, if I'm not mistaken, and forgive me if I don't have it completely in my head, I think it's 10 days the normal thing is like 10 days to reply. One of the big advantages of EUIPO is that as it's very easy to because information is already there at the tip of the fingers, and replying is very easy, and it gets to the right holder immediately, to the contact point it has to get. The exchange is extremely fast. So those customs authorities who have started using this are extremely happy because it speeds everything up. Yes, and there's something I have not mentioned before. As you know, in the EU, we work in different languages, different member states. So the tool works in 23 languages. Basically, we work with drop-down menus, and the interface is translated into 23 languages, which means that the enforcement authority, the Bulgarian customs officer, can view the interface and send a suspicious case in Bulgarian, and the German right holder or the whatever right holder can see it in English or in German or in the language he's working with. So we work in a multilingual environment, and this is for the EU is very important. And particularly in the suspicious cases, it's also very important because suddenly, especially the small and medium-sized enterprises, they have seen that they not necessarily need a legal representative in each member state to deal with customs, but they can centrally manage all the cases from EUIPO without having the issue with the language barrier. I think this is also something important to point out.
Yes, thank you. And actually, that was one of the main, functionalities. I think that will be of great help for right holders. And there isn't really a limitation of how many contacts, for example, a right holder can add to EUIPO, correct? For example, if they have they can also add official distributors in a different country. So there isn't a limitation. Right holders can potentially assign for each EU countries, for example, a different contact details can act and answer almost immediately to customs.
Absolutely. Correct. I mean, there's no limit, and in the contact point information, you can point out whether this contact is a technical person or a legal person. But the problem is very often the contrary. The worry that you need a legal representative in each of the member states, which is not. You can have one contact point that covers all the 27 member states and covers both technical and legal aspects. As I said, depending on the size, EUIPO is fit for big and small companies. So depending on the size of the company, they may have just a legal representative that deals with the AFA management and is also the contact point. In AFA language, it's called enforcement contact. For all the member states and for both technical and legal aspects. But of course, if it's a big company that have specialized people who can go down to the warehouses and really check if something is fake or genuine, or this is of course all this information can be entered, yes, and then specified member states by member state.
Thank you.
Yes, so we move on. Very important to stress that the use of the IP enforcement portal is for free. There is no cost involved. This is fully supported by our office. Of course, security is our obsession. We handle very sensitive data that is stored there. I must stress out that the EUIPO, we are not an enforcement authority, so we don't see the content of your accounts, of the right holder accounts. We're blind to that. The right holders can share product information with us when we go to trainings that we can use it, but unless they explicitly open the product information, we don't see it. We can see the company information, but any other information as the exchanges, the AFA information, all this we don't see. We don't have access, so this is very important to stress out. We have the same security standards as online banking, so we undergo yearly audits. We have the security audit, the SOC 2, to make sure that we are compliant with all the protocols and the thing is really safe. And yeah, as I mentioned, as I stressed out, we work in a multilingual environment, so the tool works out in 23 languages, which has also the advantages that when right holders file customs application instructions through EUIPO, and they do a union AFA and it's applicable in all the member states, the AFA is automatically generated in all the 23 languages. So again, we overcome language barrier and we overcome the issue of right holders having to provide translation of their AFA. It's not necessary because we automatically generate them in all the languages. Next slide, please.
Fantastic. I can only imagine the time saved for right holders, so thank you. Next slide.
Yes, please. Okay, state of play, where do we stand? Right now in EUIPO has been existing. It was first launched in 2013, but then of course we needed to integrate with customs. With customs, we are federated into the secure internal network. So that took some time, and then we had to get the companies on board. So the whole thing was a slow process. Today we have over 1,000 companies registered, which is not bad if you think that more or less the overall number of customs application instructions for the EU are like around 4,000. So we pretty much cover big ground already of what is the enforcement environment. We have around 37,000 IPRs uploaded, some 5,000 products of product information in the account. And what is more important, we have 72 enforcement authorities accessing the account. That's EU customs of the 27 member states. Basically police authorities from all the member states. And then, of course, we have also some other forces like market surveillance authorities. And we have Europol, Eurojust, OLAF, which OLAF is the European Anti-Fraud Office. And then last but not least, we have the prosecutors on board. So some prosecutors also checking on the information. Accesses per month per authorities, we have around 500 accesses a month. 500 accesses EU-wide. Behind each access, there may be many searches. So it's just an idea that to show that the tool is also used by the enforcement authorities. Next slide, please. To get an account in the portal, we don't work with powers of attorney, that would be impossible, but we need to authenticate the right holders. We need to be sure that the person who says that they are a company so-and-so and want to enter some information are really the company and are authenticated. So what we do is a very easy protocol. We ask for a trademark number, and then we go to the trademark register and see who is the registered owner of the trademark and what is the registered address. And to that registered address, we send per courier a letter with a safety code. And then the person who gives us a safety code back, it can be the company, it can be the legal representative, it can be internal, whoever gives us the safety code back becomes our contact person and is then the person who will authorize other accesses to the account. We have legal representative accounts, of course. So the legal representative is always appointed through the client's account. So the first thing is the client account, and then whoever's the master user can go in. The master user can, as I said, be the legal representative, appoints himself as legal representative. And then the moment this happens for the first time, we create a legal representative account. The legal representative gets its own credentials and can then access the account with his own legal representative credentials. And as he gets appointed, more and more companies get added to his legal representative account. That means that he has his own credentials and can just then jump from account to account without having to know 50 different passwords. So this is possible. All the information of how this is done, again, is explained in our landing page. And there's some help videos and help material to help you to pass through. But I should also mention that right holders can also, they can register an EUIPO through this protocol. But for those economic operators that are already dealing with the Commission with DG Taxud and they have UMDS credentials, so they're economic operators in front of the Commission, they can also access EUIPO with their password. So this, if they already have a password, it's also a way of accessing EUIPO. Next slide, please.
Just a quick question, Nicole. I can see there are some questions coming through the chat, and actually I think these two are quite relevant. So the first one is there any limitation on who can access the portal once you have appointed, you know, a legal representative or not? And second question following up on that, does the contact point, any contact point, needs to be based within the EU?
No. No, I mean, you need a person who can answer the questions of customs. So let's start with, I started with the last question first. So when it comes to contact points, whoever can answer questions that enforcers have on what they've detained is a contact person. It doesn't have to be based in the EU. I mean, normally you, depending on what you're looking for, you can. When it comes to filing, and the same happens when it comes to filing customs applications for action. You don't need to be a legal representative in the EU to file a customs application for action. It's not like with the EU trademark where you need a local legal representative when it comes to proceedings. I mean, for filing, you also don't need it, but the moment a proceeding opens, you need a local legal representative. This is not the case for customs applications for action. Okay, this is very important. And the first question was, who has access? The master user, the person who sends us a safety code, is the one who can authorize any other access to the account. So this is the person that sends us a safety code. We authenticated this person, we identified this person as the master user, and it's only this person that can give green light for others to access the account. What happens is that, of course, once you're in the account, if you're a right holder and you appoint your legal representative in corresponding field in the account, then of course this is automatically. So we then give access because the tool, but it has been appointed in the tool. But if it just happens outside the tool and you just write us an email saying, please give access to this and this person, or if we get this from the master user, we can also give access. So there are like two ways of doing this.
Perfect, thank you. Move to next slide.
So just a few words of what's going on. I'm a bit time conscious, but okay. Yes, we of course, the biggest development we had lately was the EIAFA, because it's very complex, because we needed to integrate with the central tool of customs of the EU Commission, which is called COPIES, and integrate with 27 member states. So it was very complex development, which is not completely over, this whole EIAFA management. But in parallel, we're also developing other things. One of the things that we are developing is, of course, a mobile app for enforcers. This was a long way coming. I mean, this has been asked for years, that we developed an app that off iPad that enforcers can take down to the warehouses, and when they can do searches and start cases and start notifications already on their mobile app. Of course, the biggest impediment until now was security. We needed to make sure that the whole thing was safe. Now we are at the point where we, again, same standards as online banking, we can do this online too. So we're developing this app only for enforcers, because I mean, we assume that right holders are not going to start customs applications from their mobile device. But yes, for the enforcers to have something that they can take to the warehouses that they can use even if they don't have internet access or very poor internet access, and where they can find the information. This mobile app will also include a barcode reader and will help with the whole search. Then what we're also developing is, with the help of big data, the IP dashboard for rights holders. One of the points in the agenda today was the detention report, and IPEP has in one of this model all the detention data of detained goods, both at the EU border and the internal market since years. There's a lot of data out there that is not really being used, and it's very useful for trend analysis and for getting an idea of what's out there, particularly if we combine this with big data tools. So what we are developing, and it's hopefully ready for summer, is that we offer to the right holders who have an account in IPEP the information of this dashboard, and so they can also see their own data with their own products, with their own IP rights, compared with the AFA information, with the AFAs they have done over the last years, and play around with these big data tools. I mean, you all know them, they're very impressive. You can sort by sectors, by type of product, by country of origin, years, countries, whether internal market, external market. So there's a lot of data there that can really be played around with them, and then you could generate reports and have them print them and have them available. So we really wanted to make this information available to our users, and we hope this is ready for summer. Then another step, yeah.
No, thank you. I was just saying, yes, we actually wanted to mention as well about the report, but please continue. I know that you have some exciting news for 2022, so please go ahead.
Okay, good. Then last but not least, as we all know, in this big story about IPR infringements and stopping IPRs, we have on one side, we have the right holders, we have the enforcement authorities, but there are also the intermediaries. Big part of this, we always call it the triangle of stakeholders involved. When we speak about intermediaries, we're thinking about e-commerce marketplaces, we're thinking about shippers, we're thinking about payment platforms. All these players have a big role in the IPR enforcement history, and we are looking into bringing them also on board in IPEP. We have started with one project, which is with the e-commerce marketplaces. As you know, all these big marketplaces, Amazon's, eBay's, and what they call, they have their own, or at least the big ones, they have their own IP programs. And if you want to, as a right holder, you want to become part of their IP program, there's a large number of, well, you need to prove that you are the right holder and that you're able to speak on behalf of the right holder. And then you need also to hunt out quite some information on your rights, you know, to prove that you are the right holder, that the rights are in a valid status, that they can be enforced and they can be used for takedown of listings. We have come in here saying, okay, these are two things that IPEP already does. We authenticate the right holders when they open an IPEP account. And of course, we sit on the trademark and design registers. We have the information about valid rights and if rights can be enforced and who is the legal owners. So these two big parts of the play, we can help make the life of everybody, of both parties, both marketplaces and right holders, easier if they request the access to one of those IP programs through IPEP. This part of the chapter where they need to update with IP rights and where they need to send this authentication information can already be taken part of by IPEP. So this is what we've started to do. It's also something that's going to be ready by this summer. It was just the first step, so the authentication and the validation of IP rights through IPEP. But of course, we're looking into then see where we can go with this and how far we can progress also in other lines. So, but this is a first start into that direction.
Perfect. So again, trying to have different parties collaborate and make the work of right holders easier instead of submitting the same information over and over to different parties. So before we continue, maybe we can launch a quick poll. I'm conscious of time as well. So if please, you should be able to see the next poll on the screen. And in the meanwhile, of course, you can continue to share any other question on the chat. So let's see. So here we'll see the poll. Poll is still going on. Actually, the majority, now 59%, does not currently work with customs. 24% yes on a regular basis, and 60% yes, but not in the last year. So this is very interesting. Again, the registration of an account with IPEP can actually help anyone who is not currently working with customs. And again, thank you to Nicole, can make certainly the process much easier. So thank you anyone who has answered the poll. And Nicole, back to you again. I know that we are towards the end of our presentation, so maybe again we can continue on to the next slide.
The idea is, as you very nicely said, we're trying to bring all players. The idea is that the right holders have one place where they can put the information in, and then Depending on who you are, you will have access to different information. So if you're an enforcement authority, you will see one information. If you're intermediary, we started with the e-commerce platform, you can then see the information that's dedicated to you, but not the other. It's always on voluntary sharing and on limiting who can see what. And it's the right holder who really decides who can see what. There's also, there's a big pressure that we open EUIPO also to non-EU authorities that would also like to access this information. And again, there we're also looking into that. We are in contact with the World Customs Organization, and we will start bit by bit. So first with the neighboring countries and like European countries that are not in the EU, but then also look at we'll probably start first with the US and Canada, and then go bit by bit, opening also to non-EU authorities. But always the principle is the right holder decides what he wants to share with whom, and differentiation of who can see what. And besides, I'm finished. I mean, if you move to the next slide, very important, there's our email address where you can contact us, the IP enforcement portal, with questions. And if you Google the IP enforcement portal, or you just Google IPEP and EUIPO, you will immediately go to a landing page. And in the landing page, you will find videos, help materials, and user guides, and all the information you need to open an account. And our team is always there to help.
Yes, and I know as well that you host monthly webinars where you can help right holders or whoever want to register, you help them through, correct? So I believe the next one is scheduled in February as well.
Yeah, thank you for reminding me on that one. Yes, what we do is for our users who suddenly are forced to use a software that they're not familiar with, we do monthly walkthroughs. It's 3 sessions online. They are announced also on a landing page. The next one is, as Francesca said, on the 16th of February. 15 hours Central European time. And what we do is we go through the tool and explain the different functionalities and a bit what I explained today, quite in detail, the reasons behind the context and how to enter information.
Perfect. Thank you very much, Nicole. That was an extremely detailed and informative presentation. So I know that we might not have a lot of time to share the findings and main trends on the 2020 joint report, which was prepared in conjunction this year by EUIPO and the European Commission. So this is the first year that these two bodies have worked together. So after the webinar, we will send the materials, including the slides, and you can read in full this report. The main takeaways from my side, at least, I found very interesting the fact that during 2020, the sheer volume of counterfeit goods seized by customs at the EU border were decreasing in terms of volume, but actually the value of the goods itself was actually increasing. So of course, this is something that you can access on the report. Something as well that probably might not be a surprise for many of our attendees is that, as in previous years, again, China has been flagged as the main source outside EU for the majority of fake and counterfeit goods entering the EU. These data can change depending on the type of goods, but China, again, overall, the main country, and then following others will see Hong Kong, specifically for mobile phones, for example, as well as labels and tags, and Turkey for mainly being the source of clothing, medicines, or accessories. So it is a very informative report. And as you were mentioning before, Nicole, this data is not just number. Those should be insights we can help, which can help, first of all, the right holders to take an overview and follow the latest trends, but also for policymakers, for example, to understand what are the main issues in terms of products, IP rights infringed, and also volume of these counterfeit challenges. Again, we will share this report in full. I don't know, Nicole, if you want to add anything about this, or maybe if you have any scoop for us. I can only imagine that the 2021 insights will be ready by the end of this year, but if you want to share anything, please feel free.
I just want to point out two very important things that are also obviously mentioned in the report. The report is influenced by both, or maybe the outcome of the report, of this report is influenced both of the pandemic. So especially when it comes to the beginning of last year, and of course of Brexit. And we cannot forget that if we look at the figures of 2020, which look into, I mean, it looks into this year report looks into the figures between 19 and 20. These are heavily impacted by Brexit. I mean, we lost there a big chunk of data, and when looking at the figures, it's mentioned in the report, but just that you have it in your minds. There's a big part that was suddenly missing when you compare it to previous reports, and this should always be taken into account. And yes. I think that was the main thing I wanted to mention.
Thank you. You're correct. Of course, 2020, especially for custom, for example, they were working in some instances with limited personnel. Some of the goods, of course, maybe were not transiting because of the pandemic. So, of course, this data also has to reflect that. Thank you, Nicole. Again, thank you for your time. I'm now, let's see, Ida, let's see, maybe do we have any questions from our audience, and do we have still time actually to address some of the question before ending our webinar today?
Yes, I think we're pretty much at time. So thank you very much for everyone who submitted questions. I think we'll have to get back to you individually after the webinar, just to be respectful of everyone's time. I would like to thank Nicole. Thank you so much for the very interesting presentation. This was so much information in such a tight package. So thank you very much for being here and sharing all of that with us. And all your insights also about the trends we're observing and the data that you're getting. I think we all learned a lot today about the EUIPO, the enforcement portal, and I think it will encourage a lot of people to try it out as well. And we also learned about the benefits for the brand owners, which is great. And thank you to the audience for your active participation, all your questions. If there's any unanswered questions, we will address them separately after the webinar. And if you have any further questions about the enforcement portal or about brand protection, please do not hesitate to reach out to me, to Francesca, or to Nicole, and we'll be happy to continue the discussion with you after the webinar as well. Thank you very much, everyone, and have a wonderful rest of your day.
Thank you. Thank you very much.
Thank you.